The first time I'm traveling to this part of India. I rarely get an opportunity to be in this part. Usually, India ends at Guwahati. But if you go beyond Guwahati, you need some extra effort. Yesterday, I took a day off to travel from interior areas of Tripura and got to see the life of indigenous people and the diversity. So I really thank Professor Yogesh for this opportunity. And as Professor Yogesh rightly said, that I taught at two law schools, and I was part of a lot of discussions there, especially with Professor Madhav Menon. When the Menon had this graded attitude towards law versus social science. He used to also not only pitch students and teachers, within teachers also he used to pitch law teachers versus social science teachers. So we were living in all kinds of conflictual situations. So last month I was in NUJS for 20 years. The first batch invited all of us to celebrate 20 years. And one of the remarks I made there was that life after Professor Menon becomes cakewalk, because those 2 years are so tough working with him that I think, as Professor Yogesh said, I think those heading the institutions will have that concern to make the institutional life a little more formidable. So picking from that experience of teaching in law schools for 5 years, later I moved on to NLS, National Law School, Bangalore, where students were absolutely brilliant. I used to almost teach postgraduate level courses to them and had very healthy and robust debates. I'm in touch with many of them. In fact, with this government breathing down our necks, our recourse is to law students. They take up our cases and fight. Many of them have fought our cases pro bono, in JNU. So the topic I really picked was this, that interest in law versus social science. That what is the equation one should really understand with law and social science. There is a tension between these two domains. The method of teaching of law and analyzing in legal studies, and the method of analysis much of social sciences, whether it's political studies, whether it's history or sociology, is distinct. There is a tension. Second part of my lecture, I will try and demonstrate a case study by taking some contemporary to analyze as to what is the nature of this tension. And final part is to persuade all of you to think that we need to do something to reconcile. We may not be able to completely equalize it, but partly reconcile this tension, because this tension is, to reconciling this tension is not only important to change legal pedagogy in the country, but also for the future of democracy. That this has an implication for larger, implication for policy making, larger implication for understanding constitutional dynamics in the. So, with the limited time, I will be able to push through some arguments. I have explored this in my own book, Politics of Post-Civil Society. Those of you interested, take a look. I have a chapter on gender and law, that how law and feminist politics have been at loggerheads, that there was an uneasy relation between the two. Why should it be so? So I am extrapolating some of these arguments and pitching before you. To begin with, I will suggest you a reading that is a must. All of you should read, and encourage your students also to read to understand this tension, is Emmanuel Terray in New Left Review. He has an article titled Law versus Politics. This should be a compulsory reading for all the faculty as well as for your students. He is a French anthropologist. What is the basic fundamental distinction between law and political studies or social sciences? And Emmanuel Terray argues that law, by definition, discounts individual particularities and the uniqueness of any given situation. To act under its aegis is to apply a norm to subsume a particular case under a general rule. Politics or social sciences, on the other hand, is about appropriate course of action has to be formulated to deal with each specific situation. So law is always, the attempt in law is always to have a universal, objective, general law. Otherwise it cannot be a law. Those of you interested should also read Joseph Raz on authority. The basic essence of what is specific, what is unique about law or legality itself is that it has to be objective, it has to be standardized, it has to be universal, it has to be a general norm that is applicable under all situations. So by definition, law does not take cognizance of particularity and specificity of each situation. Instead, it says that there is a general norm that is applicable to all situations. Irrespective of the particularity of situation, law is applicable. Like a traffic law. Everybody has to follow a red light. You have to stop. You cannot say, no, my wife is angry with me, I have to hurry back home. Law will not take cognizance of your particular emergency, that it is applicable independent of any existential situation. Right? Politics and social science on the other hand. The essence of politics and social science on the other hand is how to count the specificity of each event, how to account for the particularity of each event, how to give a historical account of the specificity of each event. So if you study good historians, Romila Thapar or Bipin Chandra, their account is how history evolved, certain event evolved due to under certain specific conditions of history. So social scientists by law, by definition will always tell you there is no general theory of social science. There will be theoretical propositions, but all those theoretical propositions always are there to be questioned, to be challenged. So social science, especially the act of politics, if you see the difference between politics and judiciary, even separation, what is the difference? Politician attempts to arrive at pragmatic solutions to each problem. Law does not go into each specific. Law will see how to apply the specific situation to a general norm, to a universal norm, to a norm that already exists. So you read the situation, specificity of the situation through the lens of an objective generalized norm. That is the legal norm. Specificity of social science on the other hand is to disturb that generalized norm, to disturb the general laws of social motion or universal laws and say that no, these are not applicable because this specificity matters, this difference matters. So this, as Emmanuel Terre says, is the basic epistemic, conceptual, theoretical, philosophical tension between law and social sciences. This was also the argument Professor Menon used to make with me. You social scientists only endlessly talk, discuss. We are here for final solutions. Whenever he used to say we are here for final solutions, I used to remind him of Germany's final solution with Jews. So your law will take us to a final solution of Holocaust. Finality, but Menon used to say finality is necessary for delivering justice. We think on social science, it's not the question of finality of justice, it is how much of differences, how much of specificities, how much of differentiated social existence you can recognize. Law thinks justice is in arriving at a universal standard now, which is one form of justice. That's why I'm opening up this debate. This is an inconclusive debate. Social scientists think if you arrive at a universal objective norm, then the differences that exist in society get nullified, get undifferentiated. So all laws, if you examine closely, are always followed by exceptions. Take any law, any universal principle, there is always an exception. Indians can live anywhere under Indian Constitution, but you cannot settle in the autonomous administrative council of Tripura. Indians can hold property anywhere, but you cannot buy land in inner permit zones in Northeast India. Take any universal objective law that is based on constitutional principle, you will always have an exception. So as social scientists, as political theorists, we account for justice exists in accounting for this differentiation. And therefore, our critique of legal method is that legalism through universality and objectivity becomes not only statist, but it has propensity to become totalitarian, and therefore legal regimes produce possibilities of authoritarian forms of governance, partly which we are witnessing in today's India. Today's government is doing this, the universal norms. One nation, one market. One nation, one election. One nation, one citizenship. With that view, which they will call is a legal view. Because citizenship is based on universal principle, which is a fact. So they would, from this viewpoint, they will say, having an inner permit zone in, having these exceptions in Northeast is unconstitutional. They will not only say unconstitutional, it is also a form of injustice on the rest of India. Why should an Indian living in Delhi, why can't he buy land in Tripura? If you see as an abstract principle, it makes sense. Yes, why should we not buy? It's our right. We should be able to buy. We are Indians. Why can't I travel to, why do I need special permission going to some zone of India? It looks straight. So person sitting in Delhi thinks like this today. This is not this, people are getting all kinds of benefits. They don't want to identify with India. But when you see the history of Northeast, when you see the specificity of each zone, that there are backward regions in India, economically backward regions in India, socially backward regions in India, regions with different regional histories, different ethical sensibilities, different cultural, you have tribals who are vulnerable, who are not socio-economically or politically or educationally so well equipped to compete with outsiders. When you see this specificity, then it makes sense why Constitution should recognize differentiation. So what you should be looking, therefore we would say, law and Constitution prescribes universal citizenship. Social scientists, we prescribe differentiated citizenship. You should all read a political philosopher by the name Iris Marion Young, who offered this concept of differentiated citizenship. And social scientists therefore argue that any idea that pushes for absolute, objective and abstract notion of universality, it always has a propensity to become a tool for domination for those social groups which are already dominant. Today if you make this law in India, any Indian can buy land anyway. It looks objective, it looks very neutral. But we know what will be the social consequence of us. Big businessmen, moneyed people living in Delhi can come and buy half of your land in Tripura. And you might ask, what is wrong with it? Why should you not have? The same law applies in monopoly. In competition, you can say competition in the market. But out of that competition, if monopoly emerges, like in today's economy, should we intervene? Should government, politicians, political parties intervene and make, like MRPT Act, we had Monopoly Restrictive Trade Practices Act under Mrs. Gandhi. Why did we have such an act? Because you know that out of competition monopolies, once monopolies emerge, there will be great inequalities and social consequences for inflation, pricing and other things. So therefore you have to intervene and restrict. But somebody might say, justice in a market is free exchange relations. Why should, who is government to intervene? We'll come back. I'll open up questions at the end of the discussion. Otherwise, I'll lose trend of my thought. So, okay. So, this is the basic problem that, Emmanuel Terry raises, where he argues that, I'm quoting him, antagonistic, the relation between law and politics is antagonistic because politics is the improvisation of a reposite to a specific unforeseen event, whereas law, aiming to establish uniform standards of behavior and social stability, submits action to preordained rules Law is all about how to submit to preordained laws. You have a legal framework and you want to interpret each action, each event, each policy, whether it is within the legal or outside the legal. That's how policy making happens. While politics and social theories or history will tell you that it is not a preordained law, because this empty preordained law always represents by default, that universality by default is the universality of the dominant social groups in the country. So if you make a generic gender law, all workers should work for 8 hours. All workers should work night shifts. Fair. We know there is a gender dimension to it. Women will have specific social problems of security, family, that they cannot come. So if you look at entire feminist discourse, that was the debate. Should women have specific separate maternity leaves? It was a big debate in feminist studies, because specificity then, to further complicate argument, it cuts both ways. If you give specific maternity leave to women, on one hand you are providing them relief, on the other hand you are saying motherhood is exclusive business of responsibility of women. That's a debate. Then we introduce maternity leave also. No, men also should take responsibility. They should also get 15 days. It's a different matter. Most men take leave, do nothing. They enjoy, see it as a vacation period. 15 दिन का they'll go out with friends to enjoy holiday. So how law has to be continuously informed by the specificity. Tomorrow if the legal authorities recognize that this is what men are doing, taking leave and going holiday, you might have a new law prohibiting men from taking holidays in those 15 days, and they should send photographs to the authorities taking care of the baby. You might have a new law, we don't know. So point is this, generality of the law cannot capture specificity. So the bigger question is, does justice in modern democracies, can it be achieved through generality, universality, standardization, or can justice be achieved in democracy through continuous recognition of specificities and being open-ended? That is where Emmanuel Terry says that we cannot, modern democracies cannot bend to either ways to the extreme. You cannot do without law in modern times. You also cannot do without recognizing specificities and particularities. So, Terry is posing a big question to us. His argument is that a social order run solely according to existing laws would either be one in which all eventualities had been foreseen and government could restrict itself to administration, or one that condemned itself to be wrong-footed by every external development. Conversely, a society wholly without law would be either anarchic or despotic. In either case, it would be subject to permanent instability, total unpredictability for its members and its neighbors, rapidly becoming intolerable for both. So if you have only law-based societies, it would be a very conservative government which looks at permanence. If you have only social-oriented societies, then no law is possible, then societies can turn anarchic. And you can see this debate is relevant in all modern democracies. Look at the debate on basic structure of the constitution. Should we have one basic structure in the constitution that we should consider permanent? Or should all constitutions be open for continuous change? So we have arrived at some consensus, no, there is some basic structure, but you can have amendments. This is a provisional, but the tension remains. Now what is basic structure, how much of basic structure we are following, you guys know better than me. But judicial intervention is always about impressing that there is some basic structure, basic standard, to which all of us have to submit. Because through that, you tend to bring stability. But if you emphasize more on stability, it can tilt towards authoritarian. Well, everybody who does not fit the generalized rule then becomes an exception to be excluded. Every specific historical event becomes subject to exclusion. Whether it's gender, whether it's religious minorities, whether it is ethnic tribals, whether it's ethnic communities, all this could not have been included into the Indian notion of citizenship. If Indian constitution makers, if you read Constituent Assembly, the entire debate was this: how to include the specificity without disturbing the general notion of universal citizenship. Those who came from the other side of the divide after partition, how should you give them citizenship? What are the new norms? They are not born here, they are not descendants, so you have to make amendments to Citizenship Act. But if you completely make the social, political, legal process so fluid, even then it can lead to another kind of anarchy in democracy. Then what are the standards? By what standards will you analyze the political and social process? Because to analyze any social and political process, you need basic. This is an abstract debate that cannot be settled in an abstract debate. This is a debate that needs to be analyzed in the concrete. So I will take you now to one specific study, a very interesting, fascinating study that all of you should yourself read and also introduce it to your students. It is a study by one post-colonial scholar and political scientist named Partha Chatterjee. Have some of you heard his name? Partha Chatterjee? Wonderful. He belongs to Bengal, a leading global political scientist, worked in Colombia for a very long time, retired. Title of his book is Politics of the Government in 2004. In this book, what does Chatterjee do? He argues that in Indian case, you have two domains of social existence, he says. One domain is the liberal, constitutionally informed social domain called civil society. In this idea of civil society inhabits modern, educated, professional, English-speaking, middle classes and upper middle classes, perhaps like most of us. These are the citizens who inhabit civil society in India. When something goes wrong with them, they take recourse to law. They go to judicial. They take recourse to the instrumentality of rights. They believe in legality. They approach the judicial. But, he says, this is not available to majority of population in post-colonial democracies. It's a wonderful idea where he makes the intervention. The rest of the groups are what he refers to as population groups. Civil society has citizens, the rest have population groups. The example of which is landless laborers, urban poor, migrants, those in informal sector, slum dwellers. And he gives a wonderful example of Kolkata, where most of the slums are squatter communities. How do slums get formed? The people from surrounding villages come to urban areas looking for work as domestic workers, as construction workers, right? What do? First thing they do is put up their shanties on government land, illegally living. Then they begin to look for work as domestic workers, men look for work as construction workers. He says, people, the urban poor, the informal labor, the domestic workers are population groups who live a paralegal existence. Middle class professionals like all of us working in law schools, universities, English speaking, we are by definition proper citizens because we are in the ambit of law. We have professions, we have contractual relation with the state. If the contract, if your university violates your right, terminates you illegally, you take recourse to the courts. But his question is, what do those groups do whose very social existence is paralegal? A slum dweller, if a government evacuates a slum, he cannot go to court saying, I have a right to occupy this government land. He cannot say that. All courts will say he has to be thrown out. And if you observe the slum, they take illegal water connection, they take illegal electricity. If the electricity wire is going, they'll pull the wire and take. That's how they watch their Netflix. If there is a water pipe going, they'll drill holes and take water connection. That is how they get access to safe drinking water. Now, we can, from sitting here as middle class, and most middle class do this. They say, no, all this illegality is going on in India. Very easy for us to say it's illegal. But the question again, Partha Chatterjee is, why do governments not dislocate these people? They can easily evacuate these slum dwellers. Why do they not do? One, they provide cheap labor. That's economic reasoning as to why all governments in the world, not just India. Look at the illegal immigrants in the United States, the Hispanics, the Mexicans. If the United States wants it as a surveillance state, it will only take them 1 week to evacuate all Mexicans from the United States. But the United States does not do it. Why? Because Mexicans provide cheap labor. That is a boost to the economy. Second, more important point Chatterjee is making is that these people who illegally dwell, take to elections, their first thing they do is get voter ID cards. That is why this SIR is such a dangerous business, because the heart of it is dislocating these people. Yes, you might find many people being illegal, many people may not be able to prove their citizenship, many people may not have Aadhaar card. That's the problem. If you take a pure legalistic view, you will not understand social realities. You might say, some illegal hai, Bangladeshis hai, Northeast udhar aa gaya. You can remove them, you can kick out in a legal process. But why do governments not do it? Once you are sensitive to these historical, social inequalities, specificities, then you know why people have come to urban areas in the first place. Because they have been displaced by your own agrarian policies. Because of sustained agrarian crisis, people forced to migrate as daily wage laborers to urban areas. So a pure legal view will eradicate this historical specificity. You will only see them as termites, gooseberries. You will be forced to use that language because they look like that through that legal lens. You look that they are spoiling your urban spaces. But if you look at who created these gooseberries, who created these termites, where did they come from? Many of them were happily living in their rural areas, many tribals living in their forests. You go encroach the forest, you do mining in those forests, displace the tribals. Look at Chhattisgarh, what happened in central India. Then these tribals are forced to become urban workers. When they come to urban workers, they don't have paperwork. They are forced to live illegally on government land through slums and huts and shanties. They cannot take recourse to law. They cannot take recourse to the language of rights and judiciary. What do? Chatterjee says they take recourse to the idea of democracy. So he says there is a conflict in India between modernity, modern liberal institutions, judicial logic, juridical logic, and the logic of democracy. They get hold of voting cards. They convert into a vote bank, elect public representatives, who then manage their illegal existence. So he is upturning, Chatterjee is upturning this logic. Therefore, he is saying it is the creative power of community that people use to become vote banks. Many of you must be criticizing, ये तो vote bank है. So logic, vote bank politics. Who are the vote banks? Vote banks are women, Dalits, Muslims in India. Upper caste may never become vote bank. It's a different matter. They are all vote bank for the BJP. That's another logic, which is also not true to say that men and upper caste are not vote banks. They are the first kind of vote bank. To counter that vote bank, people have to become vote bank. So why do Muslims all vote for certain parties? Because the only resource they have is the numerical resource, the numbers. Only when they vote collectively can they make their power. So they don't have economic resources, they don't have social resources, they don't have political rights. They have paralegal existence. Why are women becoming a major constituency? You must have all read in Bihar election, women is emerging as a new constituency. Why? Because women's demands, women's needs are not taken into account in the regular course. So women then have to become one single constituency, vote for a party to demand prohibition, curb inflation, to give extra benefits to girl child, give her bicycle, give benefits to housewives, 1,000, 2,000, so that she has economic independence. She becomes a vote bank. But modern rationality, modern even constitutional rationality will tell you vote bank is undemocratic. You should not think individually, rationally and vote for the choice of your own party. But democratic politics, where democracy means holding the power accountable, you will have vote bank politics. So Chatterjee says vote bank is the sign of a good, healthy democracy in post-colonial societies. Because they are able to contain the overreach of the state, overreach of the judiciary, overreach of the dominant social groups, whether it's upper caste, whether it is the rich, whether it's urban professionals living in cities. It is their logic to say individual rationality. It is their logic to speak in the language of rights. It is they who have recourse to constitutional means. But the underprivileged and the poor always take recourse to this paralegal existence. So paralegality is also, so now you can see the difference that I began with law and social sciences. Paralegality then by default becomes the account of a historian, of an anthropologist, of a social scientist. Because this paralegality itself has been created by a structural logic of capital. Law does not feel the burden of taking this invisible structural logic. Law in that sense is very, very empirical. That's why you guys follow case study methods, precedent, case laws. It's a very empiricist method. Law and legal method in one sense is incapable of accounting for this structural logic, because there is an invisible logic that is working in society. So law is right in its own place to say illegal immigrants are illegal. But law does not know how to account for where is this illegality being produced from. Tomorrow, suppose if you remove special permit zones, inner permit zones in Northeast, you remove this autonomous district council, what will happen? You bring a law, universal law, everybody can buy land wherever they wish. Most of those millionaires living in Delhi, Mumbai, Hyderabad, Kolkata will come and buy up all this land. The tribals here will be flushed out of Tripura. They will become illegal immigrants in Delhi. They will become illegal migrant workers in Delhi. This is historic. Because you began socially in a differentiated situation. Tomorrow state says that no, I don't care where they came from. So you need a social check on the legal universality. But my last submission therefore is, how do we reconcile these two dynamics? This is a challenge modern democracies across the world are facing. Does it mean taking social, then you cannot have a generalized law? Can modern societies work without generalized universal laws? Difficult, right? It will become anarchic. You need some general frame for all of us to be collective, because there will always be conflicting interests in society. So here one should see, therefore, a new way of framing this, to see law as a reconciling instrumentality, as an instrumentality of reconciliation rather than as an instrument of state. Can we reimagine this law as an instrument of reconciliation? That is a big shift that we need in modern democracies. The permanence of law, once established, so the strength of law should not come from this argument. What is the justification, modern justification of law? That it is objective and that it is technical. This technical is a very dangerous business of law. The technicality of law is what makes law unreachable for majority of people. That's why you have to engage a lawyer, and Gandhi was critical of lawyers. Where does this idea of technicality of law come from? It comes from this idea that it is objective and scientific. So you produce an objective scientific rationality for law. Another German philosopher with the name Jürgen Habermas argues that it is this technicality of law that in modern society has colonized what he calls the life world. Life world is where you have cultural life, communicative. So he makes distinction between two types of rationality, instrumental rationality and communicative rationality. The social life is run through communicative rationality, where we want to talk, deliberate, discuss, understand, and reach a consensus. Law runs to modern technical rationality. It makes every problem look technical. Rule bound. Where do those rules come? Those rules come from previous rules. Where did that previous rule come? It came from a previous rule. That's why this case law method, precedent don't take. So this technicality in modern democracy, the role of experts. So Habermas says one reason why democracies are collapsing and in crisis is because of the expanding role of experts. Economy, you have experts. Law, you have experts. Constitutional, you have experts. In fact, you guys are in the business of producing experts through law schools. Legal experts. Habermas says experts are a big threat to democracy. So how to reduce the role of experts? How to reduce the role of technicality? How to reduce the role of this idea of false idea of objectivity and scientificity? In social science and history, we are arguing that look for more differentiation. Make space for a lot of differentiation. Make law communicative. Bring the life world questions into courts. That is where law has to be today seen more as an instrument of reconciliation rather than an instrument of ideology and hegemony. State has a very colonial attitude towards law, that it makes a law and it wants to impose irrespective of what are the real-time conditions. That is the kind of technicalization of law that we need to question and bring this social dynamic, which is not to say we should remove importance of law, but rethink the nature of our understanding of law. That law is not necessary because it's technical, because it's objective, because it's scientific, because it's abstract, because it's universal, or because it's standardized. These are the 6 arguments that law argues. That we have to shift from there and now find a new legitimacy for law, where law is about reconciliation, law is an institution of mediation, law is an institution, because even in law, courts now you have new mediation, arbitration method has come. Courts themselves are telling, mostly in family law, go for arbitration first, go for outside court. Because courts cannot deal with family disputes, for instance. You You have Article 498A, domestic violence. Most women in this country take recourse not to break conjugal relations, law to create a deterrence and make their husbands a little more responsible. They don't want breakdown of marriages. But law will see in black and white. Once you have complained, husband has to put in prison. There is no via media, no, that's not what most women want. How do you create this space, this grey space, where there is deterrence, husbands become more responsible, they don't take recourse to domestic violence, but at the same conjugal relations don't break down. People don't want marriages to break down. They have children, they have families. Marriage in India is a larger community responsibility. Can law recognize this need of women? I'll end by giving you an anecdote where there was a case in Andhra Pradesh High Court, a domestic violence case, where a woman was filing the case, but the moment she knew that she would win and the husband would be punished, she used to withdraw the case. And she filed the case 2 or 3 times. Third time, the judge lost his temper and got the woman arrested, saying you are filing false case. But the reality was she was not filing a false case. She was a victim of domestic violence. She wanted her husband to become responsible and not arrested and taken action. I'll stop here. Thank you.
There will be law which is permitting everyone everyone to purchase land in some part of the northeast or elsewhere. The law permits it, or if the law permits it, it is definitely going to affect the biodiversity, culture, ethnicity to many extent, for which the local protest is always there. That's what I'm.
Yeah, you're adding the point. Yes, absolutely. So through protest you have to make logic. Then none of these specific exceptions will exist.
Same thing happened in Ladakh also. They are same thing, they are protesting because of the invasion of the business people occupying land and opening hotel resorts and all. Going to kill the medicinal.
So environmental activists have to jump in. State does not take recourse. Now in Delhi right now, there is a case of Arabali Hills being broken down. It's disastrous. Arabali Hills stop outside pollution from coming in. They are responsible for blocking the clouds for rainfall. Now you are saying that new real estate will break down all the laws, all the hills, and they have given the definition 100 meter. Anything below. Most Aravalis are 80 to 90 meter. 90% of Aravalis don't come under this new law. So you make a preordained law knowing that this is what you want to do. So can such a dispute be settled within law? No, it cannot be. Somebody has to tell about biodiversity, somebody has to talk about environment, somebody has to talk about so many other issues of pollution.
Even in Shimla last year, when that rainfall was there, that was basically as compared to the land, there is more population living over there, as compared to what they can permit. That there was a disaster basically. All these things are taken into consideration.
Any other questions?
Sir, as you talked about, there should be no expert or experts are threat to the democracy. But sometimes experts are also helping in addressing the specificity of a situation. So then how
do you
will understand this, that experts are threat to democracy?
So there I think the central question is that those experts are driven more by social concerns than technical expertise. So you might need certain technical expertise, but that has to be informed by social concern. But when we appoint experts, that is not our criteria. Our criteria is merely expertise. So that is where the disconnect is, right? And most times these experts are actually anti-social. They have no social concern. They are not concerned about gender inequalities, domestic violence. They are not concerned about poverty, distress migration. They have some notion of expertise and they technically apply those norms. That is the problem. So if experts are socially informed and that is the source of their expertise, that expertise is welcome. Then that doesn't colonize the life world. Okay, thank you.